as to why you haven't done it? Okay, so hopefully throughout this presentation today, my goal is to make sure that if these are some doubts that are in your mind, that we wash those away. So when you leave here today, you think, oh, okay, this does not apply to me anymore. I need to leave out of here today and go get me a will, go get me a trust, okay? If that's not you and you leave, I want you to come up here and talk to me, okay? Next slide. So what is an estate? Anybody want to take a shot at telling me in your own words what an estate is? The state. Okay, so the state is Arkansas. What is an estate? If you put an E on the front of that, anybody want to take a shot at what they think that means?
Would it be all your assets?
Mm-hmm. All your assets. Yes, that's a part of it. Anybody else want to take a shot? One more person. Give me a shot. Property. Yep, that's a part of it too.
Everything you own and what you want to happen to it when you're no longer here, including property, money, insurance, all of it.
Absolutely. All of you are correct. I'll add one more piece to that, though. Next slide, please. Your estate is actually all the things you mentioned. So it's your material things, your possessions. So if you have a house, car, bank account, the clothes you're wearing right now, your jewelry, all those things are part of your estate, okay? But there's one other thing that we're not mentioning, and that's your body. Your body is also a part of your estate, okay? So who's making decisions for your body if you can't make them for yourself? Okay, that's a part of your estate, which will entail part of your estate plan. So deciding if I am in a car accident or something, I'm in surgery, just routine surgery for some type of injury, who's telling the doctor this is the care that we want to receive? Who's telling the doctor when to pull the plug? Okay, is it the person that you want to be that person, or is it some estranged sibling that's just doing what they want to do? You know, and so that is a part of your estate, okay? Your possessions, yes, which is what we all know to be, but your body is the main piece that most people don't think about. That's part of your estate as well. Next slide, please. So what is an estate plan? It's just like the gentleman said earlier. It's a plan for those things, okay? Who do you want your things to go to? At what point do you want them to receive those things from your estate? But then also, who's making decisions for you if you are incapacitated for some reason? Are you incapacitated because of age, if you're a minor? Or are you incapacitated because you have had some type of medical crisis where you're in the hospital? All those things are a part of your estate plan. The other thing I'll add, that you don't have to have an incapacity to need to have a decision maker appointed, okay? You don't have to have a medical crisis to have someone appointed that needs to act on your behalf. If you travel often and you're out of the country and you need someone to handle your financial affairs or property affairs while you're out of the country, parts of your plan, which we'll talk about here in a second, will also enable that person to be able to go to the banks, talk to mortgage companies, pay bills, credit card companies, all these routine things that you're not able to do because you're not stateside anymore. So, do you need an estate plan? Again, this goes back to those 4 doubts I mentioned earlier, why people always say, I don't need an estate plan. Well, I'm here to tell you that you do. Every single person in this room, from what I can see, are over the age of 18. Automatically, you need an estate plan, okay? Number one, because if you're over the age of 18, your mom and dad can't make decisions for you anymore. No matter how much you may want them to, you're an adult in the eyes of the law. So you have to make a nomination in writing as to who you want to be that decision maker for you, okay? If you have kids that are in college, you can't call their bank and get information unless you're on their account. You can't call a doctor's office that they visit to try to help them schedule appointments, you know, so on and so forth. So it's not just for you. Think about kids who you have who maybe depend on you a lot as well. These documents apply to them as well. Do you have a child, a minor child at that? Okay, and so if you have a minor child and something happens to you, God forbid something happens to other parent too, and both parents are gone, who's taking care of your child until they turn 18? Again, is it the person you would want, or is it someone that a judge is appointing that you may not want to be a caretaker for your child? Okay? Number 3, do you have a bank account? Okay, if you have a bank account, and I don't care if it's 2 pennies in it or $2 million in it, your family members will find a way to fight and argue over that and say, she promised me that 2 pennies. And somebody else will say, no, she promised it to me because we had a conversation on the 4th of July and she told me I could have it. Okay, and so they will find a way to argue over that. And then finally, do you have a business? Most people don't think about this. If you have a business, whether it's small, mom and pop, or it's a multi-million-dollar business, you need to have a plan for that business succession as well. What do I mean by that? That means, are your plans for this business that you're building up, that you're working so hard on, are your plans for that to go with you when you go, or is that a legacy for your family? Okay? Absent some type of planning, through operating agreements, estate plans, things of that nature, that business is going with you when you go. Okay, and so if your plan is not for that to go, for it to be a legacy for your kids, you want to take some extra steps that we'll talk about. Next slide, please. So, what are the 3 components to a comprehensive estate plan? When I say comprehensive, again, I'm meaning it covers you on all bases. So, your things, your assets, property. It's also covering your body, who's making decisions for your body, and then your kids, if you have children involved. You have a comprehensive estate plan, okay? The first piece of that is going to be medical directives. This says who's making decisions for me medically if I can't make them for myself, but also a living will is part of that. And I'll dig into that here a little bit deeper, but just keep the distinction in mind that a living will is different than a last will and testament, and those two are mistaken a lot. And so a last will says, where are my things going when I pass away? A living will says, if I have a terminal illness, I'm in a medical condition that is irreversible and the doctors have said there's absolutely nothing else they can do. At what point do I want them to pull the plug, essentially? Okay? I'm making that decision for myself and not leaving that burden for my family to decide while they're already grieving a sick loved one, among other things. Okay, so living will versus last will and testament. The second piece of that is going to be a power of attorney for property decisions, property and financial. And then the third is a distribution plan. That distribution plan is going to look differently for everybody in this room. It's going to differ based on age. It's going to differ based on goals. If you have children, do you have businesses, what your asset makeup looks like. That's going to differ according to where you are in life right now. But it's going to have some type of combination of either a last will and testament or a last will and testament in a trust of some sort, which we'll talk about here as well. Next slide, please. So this is a lot of text up there. I'm sure you guys can't read, but can't see it. But that says a living will. So a living will, like I mentioned, different than the last will and testament, and it's also sometimes called an advance directive. Okay, advance directive. It just means you're choosing in advance what you want those choices to be like. If something is to happen and the doctor says there's nothing we can do at this point. Okay, how many of you have been in a situation before where you're having to be that decision maker, or you know somebody who has? You remember what that felt like, right? To be in that position. You're having to guess what this person will want ultimately. This document takes away the guesswork and takes away the stress of having to decide what their family member would have wanted, because it's written out right there. I do or do not want blood products. I don't want to be hooked up to a ventilator. I don't want these invasive surgeries if they're not going to make a difference. You know, I've had people who go very detailed and say, I don't want any of those things, but I want you to wait like 3 months and see. You know, I want you to wait. I don't want you to make it the decision right out of the gate. Just wait like 3 months, and if I'm still like this, then, you know, do what you got to do. And so that is going to be a living will. Next slide. The next part of that first piece of the comprehensive plan is the medical power of attorney. Okay, and so the medical power of attorney is also sometimes known as a healthcare proxy, and this is where you are determining who that person is that's making medical decisions for you. Again, they're determining what doctors you're seeing, what surgeries you're receiving, what facilities you're being checked into. Okay, and so this is only in the case of incapacity, meaning you can't make the decision for yourself, but you're still here. You just can't speak. You're not in a position to talk to doctors, talk to hospitals. That person is going to be your decision maker. What you want to remember about the medical power of attorney is that make sure you have conversations with these people while you're still here and in your, you know, still have your good frame of mind, because if they're going to make decisions for you, you want to make sure they know what you will want and they're not, again, guessing. This document is very broad compared to a living will. The living will says, I don't want this list of things here. The medical power of attorney says, just make a decision for me. I can make decisions for myself. And so you want to make sure they know what you would want. So have decisions about, if this is what I would, if I'm tasked between 2 surgeries, I would want this one, but talk to my doctor. Or I'm against this type of surgery. Have these conversations with people so that they know what you would want. Yes, sir. Is there a difference between a medical and a legal power of attorney? That was the question. So a medical power of attorney is a legal document. And so based on what I'm hearing, they're the same thing. And so there's not a difference between a medical and a legal. The medical is legal.
The person is coherent, but they've given all the legal affairs over as a power of attorney versus being a medical power of attorney where they're incapacitated.
So the person has given away their power of attorney, but they still have capacity? Is that?
Yes, they're still the elderly, let's say, and they just don't, they're healthy, but they don't feel like that I can take care of my own affairs, I can do this, I can do that, sign documents, this, that, and whatever. But medically, they're okay. Versus if they're incapacitated where they have this scenario.
It's the same document. Same document. And so what happens is you have the medical power of attorney. They can be drafted 2 ways. The first way is a springing power of attorney, meaning it only springs into effect. You only get the power to act on my behalf if I am incapacitated. The other is effective immediately. It just depends on the preference. I don't draft them in my practice to be springing because you have to go before a judge and have them say, I'm incapacitated for that to be valid, which wastes time and money and defeats the purpose of doing the documents. And so we draft them so that they're effective immediately. So that way you don't lose your ability to act on your own behalf, but if you ever needed the person that you have nominated to be that person, they have the ability to do so. Yeah. So this is just a list of some of the things your agent as your power of attorney can do. And so I mentioned a few of them already, but they can determine which doctors or facilities you work with, what tests to run, when or if you should have surgery, what kinds of drug treatments are best for you, comfort and quality of life versus doing everything possible to extend your life, or how to aggressively treat brain damage or disease, and so on and so forth. So they have a lot of powers here. So make sure you have some conversations with this person. The next is a durable power of attorney. And so this is the second prong of that comprehensive plan that I mentioned earlier. This is the power of attorney for finances and for property. Okay, and so this works the same exact way as the medical power of attorney, except it's only for property and financial decisions. Okay, and so you name this person, and it's a way for them to be able to manage your affairs when it comes to your property or finances. So houses, cars, banks, anything that deals with finances or property. It does not affect any medical care whatsoever, okay? But again, I'll point out that one can be used. The durable power of attorney can also be used if you're traveling, not only for incapacity issues, but if you travel often and you're out of the country, this document can be of good use in that scenario as well. Next slide. Okay, so we've talked about those first 2 prongs of the comprehensive plan, which is the medical directives, living will, medical power of attorney, and then we just touched on the durable power of attorney for finances and for property. Okay, and now we're moving on to the distribution plan. Okay, and so the distribution plan, again, is going to have some type of plan for your assets. Who is receiving my things? At what point do they receive those things from me? And are there conditions attached to the reception of those things, which I'll touch on here in a second. So the first part of everybody's plan in here should have a last will and testament at the very, very least. You need a last will and testament that says, I have $2, I want a quarter to go to all these people, 8 people get a quarter from me. And then you could also say within that last will and testament, I only want them to receive it once they've turned 25. Okay? In your last will and testament, you will also name executors, sometimes called personal representatives. this person has the job of making sure your wishes are carried out according to your documents. Okay, they have the job of taking your will, filing it in the court. Keep that in mind, because I'm going to make a distinction here in a second between the will and the trust. The will has to be filed in court. Anybody can go and search your name and see what your will said and where your things are going and what you had with that will. But that person takes the will, files it in court, and says, Judge, we need permission to do what this document says. Okay? The judge will either say, yes, it's a valid will. No, it's not. You can go and do what the document says. Okay? But it's through the probate process we'll talk about here in a second. You also put in your will who takes care of your children. Like I mentioned earlier, if you have minor children, if something happens to you, who's taking care of them? Are you deciding in your will, or is a judge deciding through court who's going to be that decision maker? Okay? You can make specific gifts through your will. Okay? What that means is you can say, on one hand, I have $50 and I want it to be split equally amongst all my children. Okay, or you can say, I have $50 and a fur coat, and I want the coat to go to my daughter and the $50 to go to my son. So you can be very, very specific or very general in your gifts through your will. The final thing I'll point out is that will, again, has to go through probate court. Anybody in here dealt with the probate courts before? Yeah, so you know how it can be, and we'll talk about it here more in depth in a second, but just remember, if you have a will, you have to go through the probate courts. So if you want to take it a step further in your distribution plan, you can add some type of trust, okay? A trust is simply an agreement, okay? A trust is a document that an attorney will draft for you, okay? You draft this trust, and it spells out what rules you have for your assets, where they're going to go, under what conditions, at what point are those distributions made through your trust, okay? And so when might you need a trust? Absent just having a will, when might you think about adding that trust to your plan? Okay? Number one, do you have special needs children, whether they're minors or adults? If you have children who have special needs, and let's say they receive benefits from the state of Arkansas, if you have a life insurance policy out there and they inherit that when you pass away, it can knock them out of qualifying for those benefits. Okay? And so a way to avoid that, make sure they can receive whatever you leave for them while also getting state benefits, a special needs trust. Okay? You might also want to ensure that your assets are managed for the benefit of your heirs, whoever your beneficiaries are, instead of creditors. If you go through the probate process, it's an ample opportunity for everybody that you owed money to or allegedly owed money to come forward and make claims against your estate. If you don't go through probate, they have no way to claim things against your estate. Okay? That's where the trust comes in. You also could use a trust to preserve your assets while minimizing taxes, okay? If you have a taxable estate, which is upwards of $13 million now, you can use a trust to make sure that your estate does not owe taxes or as much taxes when you pass away. If you're in a high-risk profession, so if you're a doctor, lawyer, people who are sued often and could have a judgment won against them for malpractice, those are other reasons why you might want to use a trust in addition to your will. So here are a couple of different types of trusts. Number one is a testamentary trust. Testamentary trust is created through your last will and testament. But since your last will and testament only becomes effective when you pass away, that trust is only effective once you pass away. And so there's a job there for your personal representative or your executor to go and start this trust. Okay, so think about that. Keep that in mind. The revocable living trust is the most common type of trust. Okay, it's effective immediately once you sign it, not once you pass away. You can sign one today and it becomes effective at that moment. It's most common because it avoids the probate courts. Okay, if you have a trust, a revocable living trust specifically, or a higher form of trust, your family never has to deal with the probate courts. They never have to go before a judge and get permission for anything when you use a trust, okay? People also like a revocable living trust because it allows you to structure how your heirs receive anything from your estate, okay? Let's say you have a $1 million life insurance policy out there, and you have 4 kids, one is 18, one's 25, and then the other are over 40. You could structure your trust to say everything that I'm leaving for you guys stays in trust until the youngest kid turns 40 or until they turn 35, whatever you want it to be, because I want this to last as long as possible for you guys, okay? And so those numbers, you can make them whatever you want them to be. The point being, you can structure it how you see fit to protect your kids, number one. Like was mentioned earlier, if you have a kid who's marrying someone who doesn't love them, and you want to make sure that that wealth stays within your family, you create a trust to say this stays in trust so that this spouse, in the event of divorce, can't touch those assets. Or if you have a child who is drug dependent and you don't want them to access thousands of dollars at one time, you create a trust for them, okay? I've had people who have children who are in prison. You can inherit while you're in prison. You just can't get it directly. You should not, for safety reasons, receive it directly. And so you can create a trust for them so that they still have it for their benefit. And the trustee's job is to go and put money on their books every month from this trust until it runs out. And so I give you all those examples to show you that it's different and it can be used for so many different reasons, but the trust is the only way you have that flexibility. A will does not give you those types of flexibilities, okay? The third type is irrevocable trust. These are less common because, like its name says, once you start it, it's irrevocable. You cannot change it absent very, very, very rare circumstances. And they're often used mostly for situations where people might need Medicaid. And so, like I mentioned, the special needs trust earlier, if you think you might need Medicaid soon, and let's say you have 2 houses, and they take you out of qualifying for Medicaid, you can use a trust, move those assets into the trust, and now you qualify for Medicaid because, yes, you have those homes, but you don't have control of them because they're in the trust. And so for terms of Medicaid, they're not there. It seems a little shiesty, I know, but it's not. It's legal. It's legal to use them that way, but they are used to essentially shield assets, whether it's for Medicaid purposes, whether it's from lawsuits, whether it's for taxes. What I want you to remember about those, though, is once you start that irrevocable trust, it's very, very, very rare that you can end it, okay? And then finally, a pet trust or gun trust. If you have animals, dogs, cats, and you don't have humans you want to leave your things to, you can do that. Okay, there was a case in the news recently where a lady in Florida left all of her assets to her cats. 2 cats. She had 2 children that were living. And they were, of course, contesting her trust because they're like, why is she leaving everything to her animals? You have a right to do that if you want to. I'm not sure why she chose to, but the kids don't get anything. Everything she had was used for her cats. Okay, next trust. So we've already talked about that one, so you can skip the revocable living trust. Also, within your distribution plan, again, that's where you're going to have that guardian nomination for minor children. So if you have children who are under the age of 18, you have the authority and the ability to decide right now who you want their caretaker to be if something happens to you and if something happens to the other parent, okay? If something happens to you and you're not there for your child and they have an able-bodied parent that's still there and willing to take them, they're going to, by default, be given deference, okay? This is only used in situations where both parents are not there or one parent is unfit for some reason, okay? And so in that scenario, who are you wanting to be that guardian for your kid? Who's the one taking care of them as if they're their own, okay? And so you nominate this person, and you can change it at any point while you have capacity before you pass away. So if you have a best friend right now who you agree that's going to take your kid if something happens, if you fall out with them in 5 years and you're not friends with them, you're estranged, and you don't want them to be a guardian anymore, you can change that and put someone else, okay? But just think about it when you're putting this person down as a guardian for your kids. Are they going to care for your child in the same way that you would want them to, okay? If you do not have a guardian nomination for any minor children that you have, and you and the other parent are not there to take care of them, they have to go through the court process called guardianship. Someone has to go before a court and say, we need someone appointed to be a caretaker for this child, okay? The judge gets the ultimate say-so on who that person will be. Your guardian nomination will go a long, long way before a judge who knows nothing about you, knows nothing about your kids, to say who's going to be their caretaker, okay? Next slide. So, what if you don't plan? If you ignore everything I've talked about already and say, she don't know what she's talking about, I'm not listening to her. What if you don't plan? Okay, That's going to end up in your family, land your family or you in what's called the guardianship process or the probate process. I just spoke a little bit about guardianship, which is essentially your family, someone you know going before a judge and being asking to be appointed as your caretaker. Probate, we'll talk about on the next slide. So, what is probate? Probate is essentially the court process where you have to file a lawsuit against yourself, essentially, because your family goes to court, enters your name, and says this person has passed away. We need permission from the court to wrap up their final affairs. What that wrap up looks like, that wind up looks like, is going to differ based on what you've done now. Okay? Do you have a will? That's going to change that entire process in probate. At that point, it's just simply, judge, here's the will. We need permission to do what it says. Simple. Let's say you don't have a will. Okay? That's where things get ugly. Okay? Because let's say you have an estate and you have children, maybe you have a blended family and you have some stepchildren involved, you have a second wife, you know, all these things. It can go really, really badly. And what's going to happen is a judge is going to say, okay, according to Arkansas law, this is the list we have, the order of succession. If you have a wife, how long have you been married? She can get X amount. If you have children, they can get X amount. If you have long-lost cousins, then they come in. If you have aunts and uncles, if you have parents, everybody's on this list that the judge is going to go down to determine where your things go if you don't have a will, okay? So if you are estranged from your children, but you haven't done a will to disinherit them, they can come in and make a claim and get what's due to them through the laws of Arkansas, okay? And so the probate process can be easy, but most times what we see is it's not because, again, your family will find a way to argue whether it's $2 million or $2 because of grief, all the other reasons that are involved. Nobody usually is in their right mind during that process, and it causes lots and lots of arguments, okay? Probate is expensive. It's time-consuming. At minimum, you're looking at 6 months in probate. As far as the fees go, you're looking at attorney's fees. You're looking at court fees. You might need an accountant. You might need a CPA, you know, to come in to do taxes or, you know, a forensic accounting of the estate. All these fees that are involved, okay? And so it's not quick. It's not cheap. I had a probate case that ended not long ago that I was the third attorney on the case. It had been going on longer than I've had a license, which is 7 years. And it was still going on, okay? And so just think about that and what that family must have been going through. Yeah. And so debts are paid and assets are distributed through the probate process, okay? And so, again, people can come forward during that process and say, well, she owed me $5,000, I never got it, you know, and make a claim against the estate. Credit card companies that you might have never paid are coming forward. All these people are being paid before your family sees a dime through the probate courts, okay? It commonly takes 6 to 12 months, and everything is frozen in your estate until probate is done. So if you were taking care of your kids, paying rent, paying bills for them, giving them allowances, all that's frozen until probate is done, okay? Next slide. So people you may know who failed to plan, okay? And so I'm sure we all know who this is, right? And so this is the thing about John Singleton. So he tried to make a plan. We all know, based on what we know about him anyway, Google, he was a millionaire. And he tried to plan, but he only had a will, okay? He had a will that said, I want my things to go to my children. At that point, 2 children, and that's it. After he had that will, he went and had 2 more children who were minors when he passed away. Never updated the will, and so he unintentionally disinherited those children. Okay, so that's the importance of reviewing your documents too. Life events that happen, you want to make sure those documents match where you are in life at that moment. He also did not have a plan for issues during his life, okay? And so what happens is he's in the hospital in his last days. There's nobody appointed as a decision maker for him. And so what do you think happened at that moment? If he's in there and the doctors are saying, what do we do? What's going on? Fighting, arguing, and they ultimately had to go before a judge and have someone appointed to be his decision maker at that point. And finally, he did not have a trust, okay, which you would think millionaire status as he was, he would need and have a trust. For whatever reason, I don't know. His advisors didn't give him a trust. They did not form a trust for him. And so what that means is he had adult children when he passed away that he was caring for. He was paying their bills, paying their rent. He's a millionaire. Of course he was. And when that happened, when he passed away, all those assets freeze. And so his children had to go before the court and say, we can't pay our bills. We need an allowance from the estate until this is wrapped up. Okay? And so they had to go before the judge and ask for that from him. And then finally, he had minor children, again, at that point. Without a trust, when his estate was wrapped up, those children, through guardians, of course, received millions of dollars in inheritance. How long do you think that's going to last them? When they turn 18, how long do you think it'll last them? If they're smart, it'll last them long enough. But who knows? You know, and so who's to say they won't go out and buy some Lamborghinis and, you know, waste it on who knows what? Absent that trust, there's nothing he can do to control what those kids do with that money. And so if he wanted them to use it for college or use it to buy their first house or start a business or use it for when they got married, you know, there's nothing he can do about it now. And that's where that trust will come in. Next slide. Aretha Franklin. Again, I'm sure we all know who Aretha is. So Aretha also died several years ago. Her estate is still in probate right now. They're still arguing about her estate in probate courts. Okay? Most recently, it was because they thought she did not have a will. Then they found 2 handwritten wills and a couch, allegedly, in her house. And so the argument was, which will is going to be the will that we recognize as her last will and testament? Okay? One of them said, all my things go to these people. The second one said something different. So, of course, everybody has, you know, something at stake here as to why they would want that will that mentions them to be the one used by the court. And so, ultimately, they decided whichever one was going to be her will, but they spent thousands of dollars on attorney's fees and court fees trying to argue about those wills. Okay? What I'll also point out with Aretha is these were handwritten wills that the court recognized. Handwritten wills, also known as holographic wills, are legal in Arkansas. Okay? And so they are legal in Arkansas. Handwritten wills are. I'm not recommending that anybody in here go out and write a handwritten will, but I recognize that it's a privilege to be able to do estate planning. It's not something that is cheap a lot of times, and I recognize that it's a privilege for people to do. So, again, handwritten wills are valid in Arkansas. This is the key. It has to be in your handwriting. Okay, it has to be in your handwriting. You can't go type it on a computer and then sign it. It has to be in your actual handwriting, and it has to be signed by you. It has to have your signature on that document and a date. Those 3 things. Okay? I point that out because, again, it's a privilege. Yes, sir. Notarized? Does it need to be notarized?
You had to go make sure it be notarized and have a witness.
No, sir. It does not need to be witnessed or notarized.
Oh, okay.
No, I've actually seen a handwritten will before that a judge struck down that was notarized but was not signed. So the notarization doesn't mean anything on a handwritten will. It has to be in your handwriting with your signature only. So, okay. Next slide. Actually, go back one more. I have one more point to make about Aretha. She had 2 special needs children. They're adults, okay, that she was caring for, paying for the care for. And so while all this is going on, they're also having to go before a court to get permission to pay for doctors, pay for all the care that they need, okay? And her children are adults at this point. So just think about that as well. Not only do you have the issue of do you have a will, do you not, you have special needs children who are missing out on care possibly because of failure to plan. Next slide. So, what can you do today to make sure that you don't end up like Aretha or John Singleton, you know, and that you do what's in the best interest for you and your family? What can you do today? So, most of these things on here are free. They won't cost you a dime to leave here today and go and do these things. Number 1, beneficiary designations. So if you don't have a beneficiary designation on your bank account, on your life insurance policy, on your retirement accounts, they're going through probate. Okay? You need to go and have a beneficiary listed, and you need to make sure that it matches what your wishes are today and that that person is still alive. Because what you see a lot of times is people will list someone as a beneficiary, and that person has predeceased them. So where does the money go? It's going through probate. Okay? So make sure you have a beneficiary designation listed, number one, but also make sure it's up to date. Organize your financial information. You can take out a piece of paper at home and write down where you have bank accounts located, where you have life insurance, what your property looks like on a piece of paper, just so people can find it. Because what happens often is people will think they know where their mom banks, their dad banks, and they have a completely different bank account somewhere. They have a $50,000 sitting in it. And where is it going when you don't claim it? To the state. Okay? So make sure that someone, at least one other person, knows where you bank. They don't have to know an account number. Just know, I have a bank account here at this bank. Okay? Governing documents for your business. If you have a business, whether it's an LLC, a partnership, small or large, you need to have governing documents for that business to, number one, say, if something happens to me and I'm incapacitated and I'm in the hospital, who's running my business? Does my business stop with me? Okay, you need someone to be able to make sure your business continues on, whether it's paying employees, signing checks, whatever the case is. You need someone to be able to do that for you. But then further than that, again, is your business passing away with you? Is it going with you when you go? Or is it sticking around for your family to be an asset for your family to continue on? Governing documents like operating agreements, partnership agreements, things like that is what's going to control that. And then finally, talk to your partners and your family about what you want, okay? Make sure that someone other than yourself knows what you want to happen to your things. If you don't get a chance to do a will, you don't get a chance to do, beneficiary designations, anything like that, somebody outside of yourself needs to know what you would want ultimately. Because what happens a lot of times is people are guessing what this person would have wanted. I've seen where families have come together and made a family settlement agreement because grandma passed away, she had a house, she had 5 kids, but everybody knew that she wanted that house to go to this one grandson because she told them that. She was vocal about that. And what we were able to do is make a family settlement agreement through the probate courts that says, yes, we recognize Arkansas says the house should go to these 5 kids, but they are all in agreement. They've signed notarized documents to say the house is going to the grandson, no matter what. Okay? So have these conversations. You can go to the next one. So that is my spiel for today. And so you guys have this QR code here. You can scan to schedule a follow-up conversation with me completely free of charge. And so if you have questions or if you just want to have like a family meeting, I've had people schedule these meetings and they bring like their entire family because they have a grandmother who won't get a will, and I'm trying to convince her that she needs to do some type of planning for her family. And so you can use this, or you can email me or give me a call at that number if you want to get something scheduled. But I'm also here now for additional questions if you guys have them.
I have a question up here. What did you say was the difference, the main difference between a will and a trust? I believe you said wills can go through probate or will go through probate. They have to, and trusts don't. Is that correct?
Correct. That's one of the biggest differences. The will must go through probate and the trust does not.
Okay. And next question, why would anybody want a will if that's the case?
So everybody doesn't have a super complicated estate. And so a will might suffice for them. Everybody won't need a trust. And so, for example, if this person is single, they have no children, and they have a house, that's their only asset. There's no life insurance. There's no other huge assets out there, and they know they want this house to go to their niece. You can do a will that says this house goes to my niece, but you can also do, that I did not mention, what's called a beneficiary deed. The beneficiary deed, you sign it today, file it with the clerk of the county where your house is located, and that says, when I pass away, this house goes here. That person simply has to take a death certificate to the clerk's office to transfer ownership. They don't need a trust to do all that. Trust will be overkill for a situation like that. Or if there's a person that is married, same situation. You can be married, but you have adult children. Everybody gets along right now. You only have this house right now. You see, I said right now they get along. You can do the same thing. And so you won't need a trust for situations like that.
So you said for the beneficiary
Deed.
deed, there you go.
Mhm.
So if it's multiple people on the property, but you want to make sure that your part, if you pass, goes to someone else, that's what you would use that one for?
No. And so if multiple people are on the property and you want your interest to go to a specific person, you number one need to look at how it's owned. Is it owned as joint owners? If so, it's by default going to the other members that own it when you pass away. If it's joint ownership, right of survivorship, that's how it happens. You can't control what happens. But if it's tenants in common or you all have equal shares, there's no joint language, then yes, you can do a will that says my interest goes here. And say, let's say that person has 5 kids, they all can move into that spot of ownership for that one specific interest in the property. Does that make sense? You can, if you can clarify for me if it didn't answer your question.
So say it's like grandchildren and children that has interest in the property.
Mm-hmm.
But I want my children who weren't alive when the stuff was set up to get my part.
So children and grandchildren all have an interest. Is it a deeded interest? Are y'all's names on the the names on the deed, or is this heir property where someone passed away and never went through probate and now it's 3 generations owning property? That's different.
It is heir property,
Mhm.
and it was made a quit claim deed. I guess you put it in the names.
Did the heir property go through the court process?
Not to my knowledge.
Well, it has to be. There's going to have to be a court process. You can't just not go through the probate courts when the heir property is involved. Okay, heir property. I'll just point this out. I don't want to go on a tangent on this, but heir property is one of the biggest reasons for land loss in the Black community. Because what happens is, it happened in my family. Grandma passed away. Nobody probated her estate. She did not have a will. My uncle moved into the house. We all let him live there. Then he passed away, and some cousin moved in. Now it's 3 or 4 generations owning this property that nobody has cleared up the title to. And so it has to be a way to clear title, which most times is going to be a quiet title lawsuit. It sounds hard because you say lawsuit, but it's just simply going through a court process to clear up the title on the property. Call me.
Okay.
Okay, so on heir property, with a will it automatically go to the heirs? Like, so if I'm one of the heirs and I pass away, will it automatically go to my children?
Without a will, it will not.
With a will?
Yes. Your interest, whenever it's cleared up, will go to your children.
Okay.
Yes.
And heir property, even with an executor, that does not give the executor any more power to the heir property as the other heirs.
So there's no executor if it's heir property, and there's no heir property if there's an executor. An executor implies that there's a will involved somewhere. If there's no will involved, then there's no executor. And the mistake is, a lot of people they'll sometimes call themselves the executor of an estate because the family's appointed them to be the decision maker with stuff, and you don't get that power absent a will or a judge. And so
if a will is in place,
Mhm.
the executor is null and void.
If a will is in place, the executor becomes the executor through the will. I know these are a lot of legal terms, but the representative, so to speak, becomes that person through a will, and they have the authority and the ability to say, our grandmother passed away and had this land or this house. I'm going to do what we need to do to make sure it comes into the names of people who are alive and not deceased. That's what heir property is. It's in the name of someone who's deceased. Nobody has probated the estate. There's no will involved. It becomes heir property. There has to be some type of process to clear up the title, and that's where the court comes in.
So if there is a will, and so there's a will in place.
Mm-hmm.
So no one person that's an heir has any more authority to do anything with the property as the other.
If there's a
Yes.
will,
Yes.
no, unless they go through the court process.
Okay.
And so that executor has the job of going to court to say, we need to do something with this property. They can't do anything with it more than anybody else, absent a judge telling them they can do it, and without getting the input from everybody else that's involved. They have the job of notifying people of what's going on in the case. And so if you have an issue with what they're doing, you have the right to come forward and say, no, I'm not okay with this, judge.
Okay, so, but you would have to take them to a probate court to get that done.
Yep, only person who can stop them from doing something you don't want them to do is a judge.
Okay.
I was just going to use example that what happened to me with my mother. I did the beneficiary deed, and I only put my name on the beneficiary deed. And when she passed away, the property automatically went in my name. And her will was that I divide the money of her house with all her living children,
Mm-hmm.
and it worked perfectly.
Mm-hmm.
So it depends on your family, because it could not work perfectly if the person.
Right.
Yep. But you got to have a little bit of integrity and honesty.
That's the key in that scenario. Exactly. You have to have some integrity, because you didn't have to split that with anybody. She left it to you. And so that supersedes a will. Mm-hmm. Yep. It's simple for simple estates, though. Yes, ma'am. I have a question over here, too.
I just have a question. You mentioned that in some cases it may be better to have a trust than a will. In what situation would there be where it's beneficial to have both a trust and a will?
So I always say, if you have a trust, in my practice, and a lot of the attorneys I know who do good work, they draft a will in addition to a trust, because in most scenarios, it's going to be considered to be a pour-over will. And what that means is, if you start a trust, just take them all. You can take all of them. If you start a trust and you forget to transfer an asset into the trust, the pour-over will picks that up and makes your intention clear that you want all your things to go through your trust. And so I explain it to clients as having a will and a trust is like having suspenders and a belt. You don't necessarily need both of them, but it's good to have that will in place if you need it, if there's ever any question about your trust. So you don't have to have a will if you have a trust, but I think it's better to have it and not need it than need it and not have it.
So the more important thing is to have a trust, and then you supplement it with the will as needed.
Correct.
Okay.
Correct.
Thank you.
Question on selecting is it executive for the trust? So my question is, if you're the youngest in your family, you got a trust, and you want somebody to take over your affairs for your children, but when they get older, how do you go about picking that person? Like, if you're the youngest, so it's not like anybody younger than you, who's going to be around to actually execute this trust? So what is your recommendation on picking people to actually
Be your
execute
representative.
the trust?
Yeah.
Because if everybody's older and you're the youngest, by the time your children get of age, who's going to be around to either take care of them or execute this trust? Is there a company or something?
Two things. And so what I always recommend if people have reservations is you can list a family member who may be older than you right now, and then list a backup option, which is a corporate trustee. And so you can list a corporate fiduciary to be that person for you. This is someone that is outside of your family, that is a neutral third party, so it really works well too. So it's not a family member being in control of your things, but it can be a bank. It can be an attorney. It can be financial advisors. Okay, anybody who can be in a corporate, a fiduciary role can be that person for you. So it doesn't have to be a family member. There's lots of corporations out here that do it often. I've used Arvest before, Simmons Bank. They all have the trust and wealth departments that'll have someone appointed for you. And how that usually works is they get a fee of whatever is within your trust, but they spell it out up front. If you have X amount of dollars within your estate, our fee is 2% or 0.5%, whatever it is. They spell it out for you. Yeah. You said there's questions on there? Oh, they can't see me. Sorry. Okay.
For someone that is trying to spend down or sign stuff over or put it in the trust so they can qualify for Medicaid, can you just talk about the look back period on that?
So the look back period is 5 years. Okay, and so if you go and start a trust right now and you think you'll need Medicaid in 6 months, they're going to look back over 5 years to see what assets have transferred out of your estate. And so you need to make sure that there's at least 5 years in between when you would need that care and when you start that trust. Because if it's within the 5 years, it's kind of pointless and it's still a part of your estate at that point. And so there's a 5-year look back period when you're applying for those benefits. Okay. Any other questions? And the spend down part of it is a big piece of it too. And so if you spend down, that's different than a transfer of assets too. And so spend down means if I have $100,000 in my bank account right now and I need to be below 90 to qualify, you can spend down that $10,000 in a way that is legal that will still allow you to qualify for benefits.
And also, can you give a broad range? I know it may be different depending on how in-depth it is, just on price of a trust, price of a will, broad range.
So it's going to be broad, just like you said, depending on where you go and what attorneys you use. I'll say within my firm, the will-based plans, and that's going to get you a last will and testament, all the powers of attorney documents I mentioned, and a beneficiary deed. And so it gives you everything except that trust. It's going to be $1,800. If you want to add a trust to all of that, that means you have a trust plus all those other documents I mentioned. It's going to run you about $3,000. Okay, and that can go up based on the complexity of your estate. And so if you have a taxable estate, meaning you're 13 million plus as far as assets go, that might change. If you have a lot of gifts within your trust, that could change the cost of it. So if you have 25 grandkids and you have a specific distribution for every single one of them and they only get it at a certain age, that changes things too. But generally speaking, most people will stay around that $3,000 range. But when you walk away from us with that plan, whether it's a will-based plan or a trust-based plan, that's all you would need. Okay.
And then the flip side of that, if they decide to ignore your advice and they end up going through probate, what kind of cost are they looking at?
Yes. So again, I recognize that estate planning is a privilege. It's a privilege to be able to go and spend that amount of money on an estate plan, okay, especially in today's economy. However, it's a lot cheaper on the front end than it is on the back end. For example, the case I talked about where I was the third attorney on, the attorney's fee on that one was $10,000 alone for me as the attorney, one attorney. The other attorneys got paid too, okay? That's just attorney's fees. That include filing fees to the court, which can run you a couple $100 as well. If there's a CPA involved, if there's realtors involved, so on and so forth. These are the fees that you see. When it comes to probate court, if you have to go through that, there's 2 different ways that you can pay for the help that you need. Most times you can agree with the attorney for a fixed amount, which is what I did with them. This is what I'll do for this amount of money, okay? Absent that, Arkansas has a statute, a law, that says if the estate is worth $200,000, the attorney gets paid this amount no matter what. Okay? If it's worth $300,000, $500,000, it goes up and up and up and tells you exactly what the attorney's fees are going to be if your estate has to go through probate court. Okay? That attorney's fee comes off the top before anybody gets anything else. Okay? Because you're essentially a creditor of the estate when it's probate. So that attorney's getting paid off top. If the attorney's fee is $10,000 and all you have left is $12,000 after everything that went on in the case, there's $2,000 left over. Okay? And so while the fees that I mentioned, again, and their general fees for estate planning are pretty high, I'll agree with you, they are pretty high. It's a lot cheaper on the front end than it is on the back end. Yes.
Can I just add, being a client of yours, that always say you can't put a price tag on peace of mind, and I've paid the fee. I'm single with no dependents. And I have peace of mind now as to where my inheritance is going. And disclaimer, remember I said single with no dependents. Mine is for educational purposes. So my information is stipulated as for higher education, voc technical school
Only.
only, because my great nieces and nephews have mamas, daddies, grandparents, all that other stuff. So they know you ain't kicking it on my money. But it's available for educational purposes. So I just want to add that. But the peace of mind is most important in
Absolutely.
my opinion.
Absolutely. Most people think when they hear those numbers, I'm paying for documents that I can find online. And that's not what you're paying for. You're paying for an outcome, which is the peace of mind that you have. It's the peace of mind that your family won't be going through probate court for 7 years or won't be dealing with what Aretha's family is doing right now. You know, it gives them the ability to grieve in peace and move on. Oh, sorry. Yes, sir.
Now, you're located in Northwest Arkansas, so how would, if we wanted to pursue this, would we have to travel there, or do you have an office here as well?
So you don't have to travel to me. And so what we do a lot of is use of Zoom. And so we use Zoom for a lot of the initial pieces of it. So the consult via Zoom or via telephone. But when you need to sign the documents, if you need me to be here in person, I do come here in person. For some people, I send them if they're able to. They say, I want to take my documents to my own notary. I did that for someone. If I need to send a notary to your house to sign your documents, they can bring the documents with them and sign the documents, notarize them while you sign them in your home. For a client today, I came down here today and I brought her documents with me because I was coming here and we signed them in an office space that I rented. And so, yes, sir, you don't have to be in Northwest Arkansas.
Just a quick question.
Yes.
When you mentioned the revocable trust, you can also add like gifts. Like if I wanted to donate to 8th Street Missionary Baptist Church, I can specify that within my revocable trust. Is that
Absolutely.
okay?
Charitable gifts. Yes, you can do charitable gifts through to charities. I've seen people do their sororities, their colleges. I've seen people even just start a charitable fund. And so you can make all those gifts through your trust.
You mentioned about for cost, you gave a cost for a will, and then you gave a cost for a trust and a will. What about a cost for just a trust?
So I don't do the trust without the will because I don't want you to have needed it and not have it. And so if you're coming to me for a comprehensive plan, I do both of them. I don't do them one or the other. If you're getting a trust.
Okay. All right, thank you.
Mm-hmm.
Do you have any more cards? I think we.
I do.
Okay. Come on, give her a hand clap. And if you need a card and didn't get one, please raise your hand and we'll make sure you get one. I am so grateful for DeQuisha and her expertise. And I will agree with what Shay just mentioned, that my wife and I now have peace of mind that if the Lord calls us home, that our wishes will be followed to the T. And she's made sure of that with the way that she has designed our plan. And I do understand that, as she mentioned, the cost for a will, the cost of a trust. Somebody may look at that and say, wow, I can just go to LegalZoom and do this myself. You want to make sure that you have a plan, a peace of mind. And it's not just about having a trust. Once you have it, then you have to fund the trust. And she walks you through all of that. And so I'm not, yes, question. Randall, is this posted on the church YouTube page? Okay. He'll make sure that it'll be posted so we can go back and listen to it again. But great information. This entire series that we've done, whether it was from the county clerk's office, from our voter registration team, Judge Humphrey came and with the information on Project 2025, the forum we had last week on home ownership from our experts there, the information that we've had on generational wealth. I believe this series has been very, very powerful, and I want to thank all of our presenters that have come in and helped us. This is such important information that I was willing to give up a few weeks of teaching Bible study so that we can get this information into our congregation's hands. And it breaks my heart every time I hear a story about John Singleton or Aretha Franklin. So what you just let me know, DeQuisha, we need to add a line to our trust that for all my unborn children, they don't get it's inherited. once we have a couple of more babies. So we have a couple more babies. I don't want my babies get disinherited. So I will add that line to Quisha. So we just had to get her on board. Amen. So when I have my babies in my old age, I always wanted to be a 70-year-old daddy. Amen. All right. So we're going to go down from this place. I'm going to ask DeQuisha, when I pray, I'm going to ask DeQuisha if you'll go to that front foyer. And anybody that wants to ask her questions, we're going to do it out there because we did take 15 minutes over, and we did that on purpose, and our choir know that we were going to be doing that because I wanted all the questions answered. But if you still have questions or want information, she'll be in that front foyer because I want us to empty the sanctuary so that our choir can go ahead and get started since we went over a little bit. They have rehearsal tonight. So please, let's fellowship in the foyer after the prayer. Amen. Amen. Let us stand. Lord, we thank you for this information that we have received. We thank you, Lord, that now that we have been hearers, that we don't just become hearers only, but we've been equipped with information and knowledge, but wisdom is actually acting on that information. And I pray, Lord, that we would exercise wisdom that only comes from you. We thank you for DeQuisha and her knowledge. We thank you for her expertise. And we thank you for the ministry that she has given to so many families that were going through difficult times, and to help families have the peace of mind that their wishes will be able to come to fruition. Now, Lord, we're leaving this place, but never your presence. Bless those who will be staying for choir rehearsal. Allow them to have a fruitful time of worship during rehearsal. And bless us, Lord, to continue, Lord, to live in your care and keep. We love you, Lord. We thank you. In Jesus' name, amen. Sister Roz, help me remember, next Wednesday, I want you to hear this, our moderator, Pastor Dwight Townsend, will be preaching his last annual address a week from tonight. So we will not have Bible study. Union District Baptist Association is in session next week. So we'll be at the Sister Cannon Longley, Liberty Hill Baptist Church next week. So our choir is singing Monday night at the musical, and then Tuesday night will be the the women's president's address, and then Wednesday night is moderator's address. So next week, no Bible study. All right, God bless you.